Welcome, everyone, to our Legal Live. It's Tuesday, and I'm your host, Craig Wagner, here at the Utah Association of Realtors, and we have Lance Harrison. We're the attorneys here. Glad you could join us. So feel free to type any questions you may have. We'd love to address those. We certainly base our legal lives on your questions. Throughout the weeks that we get legal questions, we want to address those ones that maybe you've been thinking about. And certainly it doesn't have to be related to what we're going to cover today. The majority of questions that we get on the hotline are definitely related to the real estate purchase contract. The vast majority of transactions are residential, and that is the approved form. So Lance and I wanted to maybe go back to some of the basic questions, at least found within that document. And I'll make a small plug before we begin. From my perspective as an attorney, I think your greatest value proposition that you have to offer as a realtor is your understanding with the purchase contract. I just do. It's a 6-page document. Certainly other states have much longer versions of our purchase contract, but it contains a lot within those 6 pages. A lot of things that certainly impact your buyer or your seller. And certainly your knowledge and your expertise and competency with that agreement is really going to show your value to the transaction. So I just wanted to start off with that. We're going to kind of go towards the tail end of the REPC today. We're going to first start in sections 18 and kind of work our way up from there. And so let me go ahead and share my screen and highlight kind of what we're gonna go through a little bit today. And again, feel free to stop us if you have any sort of questions or concerns. So Lance, on the hotline, some of the questions that you've been answering and been asked. First, let's start with section 18. So this notice section. What are some of the things that you're seeing, and why should this section matter to real estate agents in general?
Yeah, these are great questions. And I just want to reiterate what Craig just said about your value proposition, because this section is a good example, and several of the other ones that we will talk about is a good example where the REPC is clear if you're reading through it a lot of times. If you've never read through it, or you're not representing, you're representing yourself or something, you don't have an agent, it can seem clear, but it can get confusing very quickly. And that's why you as an agent have such an important job to understand these sections and help your clients understand them so that you are always protected. So a good example of that is section 18, right? It talks about notices. And notices are referenced throughout the contract, right? Where something is required to give notice. Usually it's talking about like a cancellation, right? Where something is required and it'll say something like written notice is required to do this action. So some kind of a trigger. But if you were just reading that on its face, that seems to make sense, right? But if you don't understand the nuances in the contract, that's actually defined, right? We come down to notices, and notices means something beyond just written notice on its face. And so that's what I think a lot of people forget, or they are moving too fast. And so we come to the actual requirements in section 18 that say, hey, if it requires a notice, all notices, it actually means 3 things, right? In writing, signed by the party giving notice, and received. So those 3 things are what constitute a written notice. So not everything is as it seems in the REPC sometimes, right? And there's several examples of this that we'll talk about. But that's, to me, one of the tricky things about the REPC.
Yeah, and this section comes into play if you've ever used some of the UAR addenda, where it talks about, again, notice, and we don't redefine what a notice is because notice is already defined under section 18. So anytime notice is required or mentioned, it's going to be falling under section 18, unless it's going to specify something different, which none of the UAR addenda clarify or specify notice in any different way other than section 18. So yes, this is going to be clear. So let me ask you, Lance, if a buyer wants to give notice of cancellation, um, and their agent sends over a text message, would that meet all the elements found in Section 18?
Well, we can go through them really quick, right? It's in writing. Great. Text, I would say that's in writing. Is it signed by the party, by the buyer or seller? So this is where we get into the facts, right? We got to say, well, it's their agent. So not exactly what it's asking for, right? And then is it received? So maybe that checks some other boxes. So, and there's always going to be arguments about different types of communications, but we want to be as safe as possible, right? If we use the forms, we're going to be safe. If we follow these rules, we're going to be safe. We don't want to have to argue about it.
Yeah, and this seems like legalese. Like who cares? A text message or an email? Why does it matter? Well, this is what the two parties have agreed to. So deviating from what the language of the contract says really puts the parties at risk. In this case, it would put the buyer at risk in giving improper notice, and therefore it wouldn't be a valid notice. And if it's not a valid notice, then there's questions of whether or not the contract was actually canceled according to the language of the contract. So it cuts both ways. It's what is binding on both parties. So definitely pay attention to the notice section. Now, Lance, let's just keep going down this purchase contract, Section 19. I know I've received a number of calls and you've received a number of calls as to, well, what about assigning the contract? What if the buyer that's under contract with the seller just doesn't want to buy the property anymore? Or maybe they want to sell their interest in the contract to buyer number two because buyer number two really wants the property. Is that permissible? And does the purchase contract address the assignability of the contract?
Yeah, so great questions. And these actually have been coming up quite often recently. And it's kind of a common question and a little bit more of a deeper question in a lot of ways. A lot of people don't necessarily deal with assignments, but it's really important for every agent to know at least the basics of some of the language that's used commonly in a contract, especially about assignment. And it does, right? It does address assignment on a general level, and it goes a little deeper than what we might think, right? It says no assignments, right? That's the general rule. But then it goes and gives a little bit of detail. It says, but, right, this is what a permissible assignment is in the contract without any other kind of agreement necessary between the parties. And we can read that. It's a little long, but it's something where the buyer has an interest already in some other entity. So if they have another entity, then they can permissibly transfer that without permission of the seller, because they've already gotten permission, right, by going under contract and not changing this language, to transfer that. Now that's the general understanding, but where this comes up a lot is where someone's writing an offer and they'll say and or assigns along with whoever the buyer is, right? And this goes back to where that on its face seems pretty clear. Oh, now I can assign it, right? But if we're careful with Section 19, it already defines what that means. And what it means is nothing changes, right? It only means it's a permissible transfer as defined in Section 19. So even though it seems like we're broadening, bringing out a lot of new benefit to the buyer potentially by using language like this, we're really not. And it can be misused if we're not careful.
Yeah, exactly. I've had those questions where a buyer writes in the buyer line and or assigns because they're deliberately trying to make the contract assignable. But the issue is that the plain language reading of the REPC already includes what happens if and or signs or anything similar to that language is put in the identifying buyer on the first page of the REPC. So it does not make the contract assignable. And Section 19 isn't necessarily saying you can't assign it. It's saying you have to have prior written consent of seller. So certainly there could be a situation where buyer and seller, for whatever reason, want to have it assigned to someone else. And if seller agrees to that, perfectly fine. There's nothing illegal about that. It's just making it clear that the default is that the rights under the REPC are specific to the buyer and no one else. So if you are planning on assigning it, then you're going to have either this section modified, or you're going to need the prior written consent of the seller to do so. So excellent. Any other thoughts about assignment or section 19 before we kind of move on to some other sections? Okay, excellent. Again, if you have any sort of questions, feel free to write them in. I'm monitoring those to see if you have any questions. I want to move forward to section 21. So the time is of the essence. We kind of hear this. It sounds very authoritative, and it has some legal significance, especially to the buyer and the seller. So what does this mean? Well, let's go through. I think there are a couple of implications in section 21 that frankly are found throughout the body of the contract. And so it's certainly you as realtors need to be familiar with section 21. You need to know what it says and what its significance. So if you look at section 21, it talks about how first under section 21A, performance under each section of the REPC, which references a date, and that would include any UAR addenda that creates a new deadline or a date, shall absolutely be required by 5 p.m. Mountain Time. Now, I understand that may not be, intuitive. You think maybe 11:59, or you think some other time period for a day or the end of the day. But the contract says 5 p.m., right? And as we talked about notice and the significance of giving notice, the significance of 5 p.m. is that that's what the two parties have agreed to, is that it's 5 p.m. Now, Lance, looking at 21B, where it talks about days and calendar days, what is the significance of 21B, and how does it why does it matter to realtors?
Yeah, it's really important, actually, because it comes to how we count maybe different contingencies in the deadline or in the contract, and how we make sure we're in agreement with what we do by certain deadlines. So this comes up a lot when we say, well, is it a business, how do we count these certain days? If I say I give you 4 days, does that mean a business day, a calendar day? No, this just tells us exactly what we're talking about and when it gets triggered. And I tell you, every time we talk about these deadlines and we talk with a group, there's always some miscommunications, and everybody's counting differently. And sometimes I get confused too, and we're all counting on our fingers these 4 or 5 days from earnest money or something. And we have to come back and simplify it and go back to what the language says to be clear.
Yeah, so let's just break it down. I even kind of downloaded a little calendar, or opened up a calendar on here. So let's move to the very first section. This is the most common section that really deals with when you start counting days, and again, what does the contract say? Because that's what's binding on both parties. So if you look at the earnest money section, it talks about how the buyer agrees to deliver no later than 4 calendar days after acceptance an earnest money deposit in the amount of blank. Let's say it's $5,000. So buyer and seller, buyer and seller go under contract today on the 23rd. What is the latest that the buyer has to deliver the earnest money to the real estate brokerage? If we're counting days, do we start counting the day of going under contract or the day after?
Are you asking me?
I'm asking Lance, and we can go back, because the answer is going to be found in section 21, right? So if we look at section 21B, what does it say, Lance?
It says that it talks about the trigger, right? Beginning of the day following the event that triggers the timing requirement. So if the trigger is acceptance, right, then the next day is number 1.
Exactly. So even though we go under contract today at 2 p.m., you start counting the calendar days on the 24th. So if it says 4 days after acceptance, you have the 24th, the 25th, the 26th, and the 27th. But is it all of the 27th, or when does it have to be due on the 27th?
Should we go back to the language?
What does the language say? Required by 5 p.m. Mountain Time.
But Craig, what if that's a weekend or a holiday? Does that just automatically get pushed forward, right?
It does not. The time is of the essence. So when we say that time is of the essence, it means the dates are the dates are the dates. So whatever the two parties agree to, that's what's binding. Now, you're exactly right. If it falls on a holiday or something to that effect, then you need to plan for it. Certainly, you're going to want to look at the calendar, and maybe deadlines need to be modified mutually by both parties. Um, the nice thing about earnest money is that it just has to be received by the brokerage. The brokerage then has an additional 4 days in which to deposit the earnest money. So there is some workaround, at least when it comes to earnest money. But certainly be aware of this. Pay attention to the 5 o'clock Mountain Time, and then pay attention to the days. Those certainly matter. Now, the last sentence of Section 21, I have seen come up somewhat recently, based on kind of the differences in the market, and kind of the pressure that puts on these third parties like title companies and lenders. Notice the language, the last sentence where it talks about title companies and lenders. So it says performance dates and times referenced herein shall not be binding upon title companies, lenders, appraisers, and others not parties to the REPC, unless otherwise agreed to in writing by such non-parties. So why does that matter? So if the lender fails to deliver funds by the contract deadlines, right? So you have settlement, and then closing is when it funds and records, and closing takes place no later than 4 calendar days after settlement. Let's say the lender just isn't ready to deliver funds. Who's liable for that failure? What do you think, Lance? The lender?
Well, if we go to the language, those third parties aren't a party to this contract, right? And so who has agreed that things will be ready or done by that time? Usually it's going to be the buyer in a lot of these senses. They're saying, hey, I'm going to get my due diligence done, or I'm going to get my financing or my appraisal done by this time. And they need to be thinking about that timeline their own, because if they can't get that done, not because of their fault, but because of the third party, that is their fault in essence, right? And they need to be extending those deadlines or making sure things are going to work out.
Yeah, and it can cut the other way. So again, title companies. So under Section 7, a seller has an obligation to provide the buyer, by the seller disclosure deadline. So that's a set period of time, a set date within the contract, a commitment for title insurance. Well, you're going to have to work with the title company about getting that commitment for title insurance. But ultimately, if the title company doesn't provide that to you, or you don't get it in time, the seller would be the one on the hook or responsible for that. So it's definitely something you have to be mindful of. And I just wanted to highlight that because we've seen that come up a number of times, where again, it's no fault of the party themselves. It's outside their control. But based on the language of the contract, there may be some consequences to the other side for that failure of performance. Excellent. Any other thoughts about Section 21 or concerns? Okay, any other questions? Well, it looks like we have one question. I have a question about waiving appraisals. So yeah, Devin, go ahead and write that in, and we're happy to address that question there. Lance, was there any other language or thoughts that you wanted to address within the REPC, or just in general?
Let's see. The other one that I was going to just mention that kind of ties a lot of this together is Section 14, right? Another one that seems pretty clear on its face. This is the complete contract section. And that just means, well, yeah, if we go up to it, this is where another one of these sections that maybe we glaze over really, really quickly a lot of times, but it's kind of at the core of what this contract means. And what this section does is it's actually looking backwards and forwards, right? It looks back and says, hey, everything we've done in the past boils down to this contract. It doesn't really matter. This is the contract that matters. And anything we're going to do in the future, needs to come back to this contract. If we're going to change something, it needs to be brought into this contract by written agreement. So this is just a really important reminder, and that's why we always talk about get it in writing, right? It's always the safest, and it's what the REPC requires is get it in writing between the parties, get an agreement so that we're always on the same page. And I can't tell you, even though these are the basics of the REPC, right? These are the basics of contract law. They come up over and over because people have an agreement or a conversation with another agent, and they are on the same page initially, right? Or they think they are. Oh yeah, we'll get this signed. We'll do this in the next couple days. But I like to treat all those as negotiations until it's signed and written and solidified. Treat those as negotiations because things can change very quickly in a few days if you don't have it in writing. So just another, and that goes along with the notices section and time is of the essence. These are all the core parts of the contract that make everything work.
Yeah, and Section 14 really solidifies what the statute of fraud says. So you probably learned that in real estate school, that in order to convey real property, you need to have something in writing. And this just goes hand in hand with that anything binding on the parties, you need to have it in writing. It needs to satisfy that. It needs to be clear. And for agents, it needs to be unambiguous, which means it shouldn't have more than one interpretation. If it has dual interpretations, then the language is ambiguous. It just is. So definitely be careful in your contractual drafting. I want you to be definitely mindful of that. So it looks like Devin did write a question. And again, if you have any other questions, it doesn't have to be related to what we've covered today. It's just more of a refresher. So here's what Devin says, and I'll propose it to you, Lance, first, and then certainly I can chime in. If I state in an addendum, buyer will pay up to $5,000 above appraised value, not to exceed the accepted purchase price, and the contract is for $380,000, and the appraisal comes in at $360,000, my buyer is only entitled to pay $5,000, making the new purchase price $365,000, rather than pay the $20,000 difference between $360,000 and $380,000. So it seems like at the heart of Devin's question is, if I write language as he stated, that buyer is willing to pay $5,000 above appraised value, not to exceed the purchase price, and the appraisal comes in low, in this case $20,000, does that reduce the purchase price and therefore make the purchase price $365,000 as opposed to $380,000? So a very specific question, but I think very general, because you and I have answered this question many times on the hotline lately.
Yeah, and it's just a great question to review the basics of contract and the precautions that we have to take as agents when we're answering questions, drafting language, when we get language that is very specific, it seems, but we have to be very careful, because in language like this, and this has been going around a lot, right? There's usually multiple interpretations, and the language isn't as clear as we think it is sometimes. And sometimes we might not even notice until someone else points it out and says, hey, this doesn't seem to say what you think it says. And then we see it from a different perspective. So in that case, I mean, what we've been talking about for the last month or so is that it can be clearer, and it probably doesn't automatically change the purchase price unless it says the purchase price is automatically changed, buyer, seller, agree, different types of language. But that's kind of the foundation of what we're working on right now, to get some clarity to those things, and also just train agents. We need to be as clear as possible if we're going to do something like change the purchase price and have the buyer and seller agree to that new price.
Yeah. So looking at Devin's question, if you wrote that language and it doesn't mention anything specifically about purchase price as far as automatically reducing the purchase price in the event of a low appraisal, but it just says buyers willing to pay above the appraised value, then it seems like it's more of a declaration as opposed to a modification to the purchase price. And that can have some serious ramifications if both the buyer and the seller are now disagreeing about a core piece of the contract, namely purchase price, right? I mean, there could be questions. Do you even have a contract if you don't have an agreement on purchase price? And so as a teaser, The UAR Forms Committee just barely approved an appraisal addendum to kind of address this scenario and make it very clear to both parties what happens to the purchase price. We hope in the next week or so to have it to our forms vendors. Definitely we'll give notice out to everyone, and we'll go through it on a Legal Live, where we'll talk about the form. It's very basic, very easy to use is what we want it to be, very simple and very clear. And that's something that we are going to be unveiling in the next week or so. So definitely pay attention to that. But Devin, if you do want it to modify the purchase price, say it. Okay. And what do I mean by say it? Then say, in the event of a low appraisal, the purchase price shall be, and then, include the language of what you want it to be. As a seller, would I agree to that language? Probably not. I mean, because unless it's capped at how low it can go, I'm not sure why a seller would want an automatic reduction of the purchase price in the event of a low appraisal. I mean, that's just me, but I think in a seller's market, they may be hesitant to do so. Another question: how come we only have addenda to the REPC and not amendments? Just curious. They serve the same purpose, but yeah, an addendum versus an amendment. I mean, they're synonymous. Would be my answer to that. Excellent. So definitely look in the next week or two. Some newer forms that we'll be unveiling and teaching and getting out to our membership. We definitely want to highlight those. Forms Committee has spent a lot of time reviewing these and trying to wordsmith it so that they're clear and understandable and easy to use. Certainly, we hope to provide some training about those new forms and highlighting them to our membership. Certainly tune in to our Facebook Lives, because we will be doing some of those new forms on this and give you the firsthand education about why we did it and how we ended up on the language that we did for those new forms. So look for those. We'll definitely highlight those. Any other things that we should address at this point, Lance?
That's all I have.
Sounds good. Well, feel free to call the legal hotline, open Monday, Wednesday, Friday, 8:30 to 4. Just leave a message. We'll get back to you as soon as possible. Happy to answer your questions. We appreciate your interaction. Feel free to ask any question that you may have. Until next time, thanks for tuning in.